Good morning, this is the Kelso Report for Friday, February 10th, and I'm your host, Clark Kelso. We begin today with an environmental law case from the Ninth Circuit. One of the complaints about environmental law challenges is that they never seem to come to an end when you start challenging particular projects. That certainly characterizes what the Ninth Circuit faced in the Save the Peaks Coalition versus United States Forest Service. The Forest Service and the Arizona Snow Bowl Resort Limited Partnership had successfully defended an agency decision to allow snowmaking at a ski resort on federal land all the way to the United States Supreme Court. Yet after that trip, suddenly some supposedly new plaintiffs appeared and filed another action with some ostensibly new claims. Now, they weren't actually new plaintiffs, since they were represented by the same attorney as the losing parties in the first lawsuit, and they had closely monitored and in some instances actively encouraged and helped finance the first litigation. Nevertheless, there was not enough of a nexus for res judicata to apply and not enough evidence of prejudice for laches to apply. So notwithstanding the frustration expressed by the Ninth Circuit at what it described as, quote, a gross abuse of the judicial process, close quote, the second litigation had to proceed on the merits. Well, at the end of the day, the district court granted summary judgment to the agency, and the Ninth Circuit affirmed, rejecting again the plaintiff's claims on the merits. And with any luck, that'll be the end of this particular dispute. Our next case involves the regulation of public parks in the United States. The Federal Lands Recreation Enhancement Act prohibits the Forest Service from charging fees solely for parking, undesignated parking, or picnicking along roads or trail sides, for hiking through without using the facilities and services, and for camping at undeveloped sites. Yet, the Forest Service collects fees from all drivers who park their vehicles in a mile-wide piece of the Coronado National Forest running along the 28-mile Catalina Highway, which is the only paved road to the summit of Mount Lemmon, a heavily used recreational area, an hour's drive from Tucson, Arizona. In Adams v. United States Forest Service, the Ninth Circuit held that this fee was clearly contrary to the plain language of the statutory prohibition, and the court reversed the district court's dismissal of that claim, letting the plaintiffs go forward to secure appropriate relief from those fees. Next, an appellate procedure case. The federal appellate courts, as you know, follow the final judgment rule, pursuant to which most orders before and during a trial are not appealable until the court issues its final judgment. There are exceptions for certain types of orders, such as orders granting, denying, or modifying injunctions, and the Supreme Court has recognized in Cohen v. Beneficial Industrial Loan a general exception for so-called collateral orders. In yesterday's decision in Metabolic Research v. Farrell, the Ninth Circuit decided that the collateral order doctrine did not apply to an order denying a pretrial special motion to dismiss under Nevada's anti-SLAPP statute. The statute did not itself provide for an immediate appeal. The court concluded that the interest advanced by Nevada's statute could be adequately protected either by appeal from a final decision, by asking the trial judge to certify close cases for immediate review, or by seeking a writ of mandate from the Ninth Circuit in truly extraordinary cases. Next, we have a class action decision. Now, one of the major advantages of class action litigation is that it can bring finality to a large set of disputes that otherwise would be litigated piecemeal. The Ninth Circuit protected that advantage in Skillstaff v. CVS Caremark Corporation by affirming the district court's dismissal of a putative class action filed in a California federal district court where there had been prior litigation involving the same claims litigated in a Massachusetts federal district court, which had certified a nationwide class and then approved a class settlement. The California plaintiff was a class member who had actually appeared through counsel as an objector in the Massachusetts case, and then filed the California action seeking to represent another nationwide class. Well, the plaintiffs avoided res judicata by suing different defendants. But the settlement in Massachusetts contained a covenant not to sue, whereby the plaintiffs released not only their claims against the Massachusetts defendants, but also agreed not to sue any other person seeking to establish liability based in whole or in part on the claims released. The Ninth Circuit enforced this covenant and held that it barred the plaintiff's purported class action in California. Next, we have a case arising under California's anti-SLAPP statute. In a decidedly odd case involving angry sports parents, an angry volunteer coach, an overactive parent organization, and a trial court that had trouble understanding what all the fuss was about, the First District held in Hesimovich versus Encinal School Parent-Teacher Organization that a defamatory statement can be protected activity under the anti-SLAPP statute, that the issue of the behavior of a volunteer sports coach towards his fourth grade basketball team members was an issue of public interest. He tried to discipline a student and a parent got mad about it, and that the plaintiff failed to demonstrate the likelihood of prevailing on his defamation claim, since he had managed not to specifically identify any defamatory statements in his complaint or in any of his subsequent filings. He kept saying there were defamatory statements, but he never pointed to any of them. You can almost sense the appellate court's relief at dispatching both the plaintiffs and defendants back to their home courts, where they can fume at each other over perceived slights and insults. Truly a waste of judicial resources. Next, a state habeas corpus matter. The petitioner, one Andrea Mims, was serving a sentence of 26 years to life following her conviction for murdering her fifth husband. One hopes the four prior ones got off at least just with a divorce. The Board of Parole hearings denied her release, notwithstanding her exemplary record during confinement, based on a finding that she lacked insight into the causative factors of her crime, her unstable social history, and the heinous nature of the offense. The Superior Court had granted the defendant's petition, but on appeal, the Fourth District held in re Andrea Mims that the Board's decision was in fact properly supported by some evidence, and that the Superior Court therefore erred in granting the petition. And that's it for today's Kelso Report. Have a great day in the law.